Welcome, 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 everybody. We are celebrating World IP Day, and I'm so excited to see you all today. And we're going to get started. I'm just sharing to a couple of groups. Invite your friends, invite your family, because we are going to be partying. Today is World IP Day. All right. So if you're watching, thank you so much for tuning in. I'm excited to be here today to celebrate World IP Day. Happy World IP Day. Okay, let's celebrate. Woo! Happy World IP Day, everybody. Let me just check my connection to make sure that you all can see me in the group. And I am so excited to have you all here at the All About Patents, Trademarks, and Copyrights room today, because we are celebrating World IP Day. Hey, Dr. Wynn, this is going to be fun because most people don't know anything about World IP Day. So first, did you even know this was a day? Well, it is a day, and it's a day that we celebrate to recognize innovation and celebrate innovation and to celebrate intellectual property. My name is Andrea Evans, and I'm the owner of the law firm of Andrea Hens Evans, a full-service patent, trademark, and copyright law firm. I am so excited to be here today to welcome you to this celebration. Prior to working at the patent office as a patent examiner, I worked as well as a trademark attorney, but now I've had my law firm, EvansIPLaw, for 14 years. So if I can help you with any patent, trademark, or copyright legal services, reach out to my firm. And I want to do a little housekeeping. I want to encourage you all to join my firm's newsletter so you don't miss out on events like this, because I'm going to be dropping some knowledge today on World Intellectual Property Day, because this is really like my day, right? Because this is all I do 24/7 for my clients: protect and enforce their intellectual property. Yes, Dr. Wynn, most people didn't even know, hey Misha, that today was World Intellectual Property Day. And you know what? That makes me happy to know that now you know that there's a day that exists and there's celebrations going on all over the world. So thank you for taking your time out today to celebrate this special day with me, because it's important to me to tell you all about intellectual property, because you didn't know it was a day, but do you even know what intellectual property is? So let's start at the beginning. Intellectual property is divided into three parts: patents, trademarks, and copyrights. So simply put, you would patent an invention, trademark the name of that invention, and copyright written work. So we want to make sure that we keep all that straight, because so many people contact lawyers and they contact my firm and they say the wrong thing. And so you don't want to spend a lot of time with someone explaining basic information. You want to have a consultation to understand specific things related to your intellectual property matter. So in the comments, let me know if you're an inventor. Let me know if you're an entrepreneur, or let me know if you're an artist or an author, because you're going to want to patent your inventions. You're going to want to trademark the names of those inventions and copyright written work. So if you invent a television, we're going to patent the television, trademark Sony, the brand name for the television, and then copyright the show script. So that's the way you kind of keep it straight, understanding the difference. So I can feel you all through this video, and I see you all kind of saying, okay, now I'm getting it. Delmar, hi. Yes, this is a party. Let me get my party. You know, I've got all my stuff going on. I had the music going. We're going to dance again at the end of this, because this is definitely a celebration, because so many people have intellectual property they don't protect, they don't enforce, they don't understand the difference, they don't understand the benefits. So if you have a dying, kind of burning question, post it in the comments. I'm going to make sure I answer your questions, because this is free flowing. Let me know where you're watching from, and let me know what you're doing to celebrate. You know, turn on some music, have a toast. I'm going to start by talking to the inventors in the room, okay? So being an inventor is super special, and it is not easy to have a patentable invention. So many people have good ideas, and you do have to have more than an idea to have something that's patentable. So I want to thank you for being in the group. Many people will post, I have these good ideas and how can I protect it? So number one, you cannot protect an idea. To have an invention, you have to be able to describe it in a way that someone can make or use it. So I want to make sure that you all are clear that if you're an inventor, step back because you have a good idea. We all have that aha moment, but you want to make sure that it's more than a concept. So I have an idea to be able to talk and see your pictures as you post. That's an idea. But the invention is software that if this happens, then that happens. So you have to be able to describe it. That's the first thing. Now, the second thing, and I know that most of you don't believe this, probably none of you because you're celebrating this day, but it doesn't matter if you mail yourself a copy of your invention and don't open the envelope. I don't know who started that rumor, but if it were that easy, we wouldn't even have intellectual property attorneys because people would just be mailing themselves things. So I always tell people just save the stamp and, go ahead and, don't waste your money on that. Hire an attorney. Okay, let me say hi to Nidella. Hello, good to see you here. Yvette, nice to see you. Misha, okay, entrepreneur for now. Yvette, we're going to talk about being able to trademark a book title. So I'm glad you posted that in the comments. And thank you, Tanya, for the emojis. So, all right, let's keep going. So none of you are mailing anything to yourselves, trying to hold those dates. But here's what has to happen for something to be patentable, because we have some inventors in the room, we have some business owners and entrepreneurs. So we're going to talk about all intellectual property, and I'm going to make it quick because I know it's a special day, and I'm sure you all are going to get off of this live and go celebrate and keep partying. So I don't want to hold you. But you have to have three things in order for something to be patentable. So the first thing is the invention needs to be useful and solve a problem. And so that should make sense. That's why you invented something in the first place. So check the box. Everybody has something that's useful and solves a problem. You hit your toe on the chair and you realize you need something to protect your toe, or you sit at the chair and your back hurts, so you invent a pillow that'll help protect your back. Whatever it is, you can always say that you have invented something that's useful and solves a problem. But let's talk about this next standard. So still you're in good shape because it should make sense to you. The next standard is the Novelty Standard. And so the question is the invention novel or new? And so what that means is basically if the invention exists, so I want to bring this up because there are a lot of different misconceptions about this too. So if the invention exists already, even if it's expired, you can't patent it. You know why? Because the invention is not novel. So you go take a trip to Mexico, you see some cool invention, you come back to America and say, oh, I want to patent that here in the US. You can't patent it because it's not new. It exists already. You go to Facebook, you see people talking about something, you can't go rush and try to patent someone else's invention. So that's the second standard, that the invention needs to be novel. So I see a lot of people posting in the group, oh, you don't need an attorney. Why hire an attorney? You can do things yourself. You need an attorney, but this is the kind of stuff you can do in advance of hiring an attorney. Because if you already know that the invention exists, then you know it's not patentable. Now, sometimes when things exist, it may not be patentable or it may not even be patented. So that means it's fair game for you to use it. What I mean by that is some of my clients are soap makers, or you make chairs or something that's just not patentable. You sell pencils. That's when we get to talking about the brands and how important the brands are. So we're going to talk about that. But before we move on, I want to tell you the third standard. This is the third thing that needs to happen in order for you to have a patentable invention. The third thing that needs to happen is the invention needs to be non-obvious. Okay, now I'm going to pause a little bit and let you take notes. So it needs to be useful and solves a problem. It needs to be novel or new, and it needs to be non-obvious. Now, I worked at the patent office as a patent examiner. The most common rejection you get when you file a patent application is the obvious rejection. Now, what that means in plain English is they combine things together, and the standard is, would someone of ordinary skill in the art be able to combine something together to make your invention. Now, that's a mouthful, but what that means in plain English is changing the size of something, the shape, the color. So you come to me and say, okay, the chair has a rectangular back. I'm going to make your back of my chair circular or heart shape. That's just changing the shape. Now, this is where it gets tricky, and you really do need a qualified patent attorney like myself to help you, because it's the most common rejection. Sometimes the patent office doesn't get it right, and you have to have a good attorney to be able to articulate reasons of patentability. Now, if you bought my All About Inventing book, everything you need to know about patents from a former patent examiner and patent attorney, then you know about this example. If you haven't bought the book, definitely check it out at EvansIPLaw.com/books, or also on Amazon. And the reason I'm encouraging you to get it is because that book explains this in more detail, but it also has this example in it. And so one of my clients basically said she was looking at the Oprah show. She said that she realized how nasty sponges were, everyday household sponges. You wash the dishes, you put some soap and water on the sponge, put the sponge back on the sink. You put it in the microwave. Some people put it in the dishwasher. But she basically said, when is the last time you actually cleaned your sponge, or when does this sponge expire? So she invented calendar sponge. So she reached out to my law firm, told me why she invented it. Seemed like a very simple invention. Basically, she took a 12-pack of sponges and stamped them January, February, March. And so subconsciously, if it's April and you're using a March sponge, you know that it's been 30 days. You need to throw away the sponge. We did research. So research is the most important part of this process, because you don't want to go in blind. Often people say they've done their own research. Again, something you can do without an attorney, but you need to hire a qualified patent researcher or patent attorney like myself to research to tell you if you have something that's patentable. The worst thing you can do is file a patent application, wait, and the patent office hands you something identical back. You don't get your money back. You wasted years of time, and you could have moved on to something else. Hey, Laura, we just getting started telling a good story about calendar sponge, so you're right on time, and it's good to see you. So basically, my client had these sponges. She did research, then she hired my firm. So the research that I found just showed a doctor, and the doctor basically said, look, we have this problem of some doctors leaving sponges in patients' bodies. So I want to put numbers on sponges to count them. Sponge number 1 is still in Laura's body, make sure we take it out. So sponge number 1, 2, 3, so they knew that they could keep up with their sponges. So we filed the application. I said, okay, this seems like a simple enough invention. Let's see what happens. Excuse me. We filed the application. Lo and behold, the patent office found that reference, because you have to actually give them the references that you find that's required, so you can't hide anything from them. So they came back and rejected it and said, we found these sponges, and the sponges have numbers on them, so just take the numbers off and replace them with the date. It's going to be obvious to do that. And so I said, well, wait a minute, that's not obvious, because the numbers on the sponges that the doctor invented are just counting, and counting is different from time. So we responded back and said it's not obvious. The examiner did more research. The examiner came back and said, okay, I found a toothbrush, and the toothbrush has January, February, March on a 12-pack of toothbrushes. So take the date off the toothbrush and put it on the sponge. It's obvious. So then we said, well, wait a minute. These are two different types of inventions. A sponge is plastic. A sponge is for brushing your teeth. A toothbrush is plastic, a toothbrush is for brushing your teeth, and a sponge is not. They don't go in your mouth. They're not for your teeth. And so we had to appeal it and fight with them. But ultimately, she got her patent for a 12-pack of sponges, or just one sponge with any time measuring stamp on it. And I'm really proud of that, and I hope that that inspires you, because sometimes it's the simplest ideas that can be profitable, marketable, or even patentable. So just to recap, and while I'm recapping the patent part of it, I'm going to move on to the trademark part of celebrating World IP Day. But if you have questions about patents or inventing or any questions, post them in the comment now, and I'm going to answer those questions before I move on. So again, to have something that's patentable, the invention needs to be useful and solves a problem. It needs to be novel or new, and it needs to be non-obvious. So even though in your heart you say you looked on every store shelf and you don't see your invention, you did your own research, that's great, but you definitely need to hire a qualified patent attorney like myself to help you research to ensure you have something patentable. I have a lot of success getting my clients patents, but it's because we do the work in advance. When you file a patent application, you can expect to wait almost 2 to 3 years just before the application is examined. So it takes that long just for them to pick it up and look at it. So guess what happens during that time period? That's a chance for you to go pitch it, market it, get out there and try to get investors, but you need to be able to articulate reasons of patentability. I judge a lot of pitch competitions. I'm involved with a lot of people that judge them and investors, and you have to know what makes your invention unique. And so if you say, oh, my sponge, soaks up water, they're going to say, well, so does every other sponge. And you all watch Shark Tank, so you've seen it play out, so you know the rest. But does anybody have any questions about what makes something patentable and inventing questions or anything about that? Because otherwise I'm going to talk about the second type of intellectual property, and that's trademarks. And Misha, isn't it amazing how people can have just the simplest ideas? And that's why I'm here to encourage you all, because it can be a problem and you can get your aha moment from watching television. It could simply be from you having an everyday problem or wishing that something happened or, existed that doesn't exist. But the key is you have to act on your ideas. And so my federal trademark is invest in your idea. You have to take action, because the only thing that separates your invention from someone that made it, someone that's on Shark Tank, is they took action. They researched, they hired the right people to get things done, and they got it done. All right, I'm going to move on if you all don't have any questions, and I'm going to move on to talk to the entrepreneurs and even inventors too, because some inventors decide they want to make their invention, okay? Because you don't have to actually make an invention. You don't even have to have a prototype to get a patent. So I want to encourage you all to take action. You don't have to spend money on making it. And that's important to understand, because some people invest in a prototype and then they come to my firm only to find that they don't have something patentable, and you kind of wasted a lot of money and time on the prototype. All right, so let's talk about trademarks. Now, I love trademarks because how many of you spent money today, right? Post in the comments, did you buy something today? Or did you make money? Did somebody pay you today for a product or a service? That means you are almost an expert in trademark law because you're a consumer, right? So we spend money every day on products and services, and we can identify what a brand is. If I show you a blue jewelry box and I show you a black jewelry box and say, I'm going to give away one of these, which one do you want? You're going to probably go for the Tiffany blue. So let's talk about trademarks and what they are and how you can protect them. And I'm going to go ahead and throw in a bonus of giving you some tips about how to create a strong trademark. All right, Tanya, you spent some money today. Yvette, did you spend money or did you make money? Both. Let's just say both, everybody. But everybody can identify with a brand, right? I can even show you a color. Did you know that an actual scent can be trademarked? Sounds like the NBC, doom, 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 that can be trademarked. Colors, words can be trademarked. Three-dimensional shapes like the Coca-Cola bottle can be trademarked. And it really is shocking to most people, but even a scent, so even the smell of something can imply and make you think of some brand, believe it or not. So start thinking outside the box and figuring out what you want people to identify your brand as, and let's talk about trademarks. So once you have a word or some symbol or some sound or one of those things that we talked about, then you have to either be intending to do business or providing a product or service using that name, or you have to be doing it. Now, when we talk about using the name for products and services. Using it means using it in and out of the state for products and services that people would pay you for. So I'm going to answer Yvette's question. If you have questions, post them in the comments, because you asked a really good question, and it's a good tip that I normally just share with my clients, but I'll share it here since you all are joining me today to celebrate World IP Day. Woohoo! Okay. All right. So Yvette asked basically about trademarking the title of a book. So let me say this. So we talked about patents protecting inventions, trademarks protecting brands, and copyrights protecting written works. So normally, Yvette, when you write a book, it's going to be copyrighted along with the title, How I Became a Lawyer by Andrea Evans. And I'm going to write the book, send that to the Library of Congress, and it's copyrighted. But everybody listen, get your notes, because if you have a series of books, then that title can actually be trademarked, because now people perceive it as a brand. How I Became a Lawyer by Andrea Evans. How I Became a Lawyer, what classes you should take in law school. How I Became a Lawyer. So now, if I get a trademark for that, and it's for that book, I can stop others from being able to use my book title. And that's really important, Yvette, because you know what I've seen a lot of during this pandemic is a lot of people writing books and a lot of people using book titles that already exist. And there's nothing you can do about it, because your story of how I became a lawyer versus my story of how I became a lawyer is going to be different. Now, if I copy chapter 1 and I paste it into my book and I make it chapter 1, that's copyright infringement, but it's something to be said about trademark infringement. So you can have the title, or Yvette, if you flip over any book, the back of the book usually has a little imprint with the publishing company. And so next to that Penguin Publishing House or whatever that publisher stamp is, you can stamp your trademark. And if you do that on at least 2 books, remember 2 because it has to be a series to qualify, it counts as a trademark. So Yvette, if you're interested, reach out to my firm. If anybody's watching and you want to schedule a consultation, go to EvansIPLaw.com. They're standing by to chat with you to answer questions about the consultation, or just click on the schedule a consultation button on my site and you'll immediately be emailed a form to schedule. And it's important to me to have consultations with clients, and I want to talk about that a little bit. So the reason I have consultations is because a lot of people think they know what they need, right? So you know enough to watch this to say, I'm an inventor, I need a patent, or I need a trademark, just tell me the cost. But the reason I don't operate my firm like that is because this process can be extremely complicated, and I have to get facts and information from you. And like someone posted in the group earlier, what we do as attorneys is a lot of strategy, because once you file a trademark application, that process can take at least a year, and it's a long process. And so what happens is, as your business grows, you start adding other things to it because you listen to your customers. Well, you're selling soap and your customers say, oh, I wish you had a lotion in this scent, or I wish you had this. Well, once you file that trademark application, you can delete products and services, but you can't add any other products and services. So that's important to understand. You have to think about all that stuff. So, whenever people post, I'm trying to do this on my own, you have a right to do it, and let's face it, I've had my firm, this year will be 14 years. Of course, when I started my firm 14 years ago, I bootstrapped different things. I answered my own phones, and I'm not saying that I couldn't do it. I can still answer my own phones, but it's the time and the stress and the things that you do best are what you should focus on in your business. And I know somebody in the comments can attest to that. You can be good at a lot of different things and capable of doing it, but it's true what people say, when you outsource things to experts and you pay the money. Someone said they were looking for a cheap way to do things. Just be careful, because cheap is relative. Just today, and people don't talk about it because I know it can be embarrassing, but a lot of people, I work with celebrities, athletes, and you'd be surprised that, and I'm not surprised that everybody's trying to save money. So someone can lure you in at a cheap cost, and once you get in and they file it, 3 to 4 months later, you get a rejection and you have to pay them more than you would have had somebody just filed it correctly in the first place. So there are a lot of different strategies and ways to make money. So you definitely want to hire someone you can trust, and you have the option to do it yourself. But what happens is a lot of people get trademarks and they're proud to have them, but you have to know what to do with it and what it means and the benefits and how to enforce it. So Laura, all right, Laura is ready for her next trademark. I'm proud to say I've been helping her. She started with one and she wasn't so sure. Oh, I don't know if I want to do it. We got it. Now she's on a roll. Can't stop Laura. And that's right, Dr. Tanya, the Weston scent. So they're different scents you can smell that can make you think of a brand. And if you subscribe to my firm's newsletter, by the way, you can text EvansIPLaw to 33777 or just go to my site and subscribe. You get a free ebook, and that free ebook talks about different things that can be trademarked. And believe it or not, an auto mechanic shop has a trademark on a grape scent. And so they were able to prove that when people smell this particular grape scent, they think of an auto mechanic store. So I don't know. I said I want to go to that store just to figure out, like, what is this scent? And it's an auto mechanic store. So it's interesting, but they knew enough to know to trademark it. So yes. Yvette, I'm going to be looking forward to scheduling a consultation with you. And yes, everybody listen to Laura. She said, hire Andrea. That's true. And this is very fascinating. You know, I really love what I do. And I'm really excited to have so many of you here tonight to celebrate World IP Day. Yay! Okay. All right, so back to business. So we talked about patents. Now back to trademarks. We talked about what can be trademarked. So let me just say this. Basically, here's what I want to tell you all. So many people set so many goals for this year. So in the comments, did you all set any goals related to your business? You know, you want to have this for your business. You want to get so many clients or customers. You want to launch another product. Well, some of you have reached out to me and said, look, this is on my list of things to do. But I want to point out that trademarks don't register overnight. So remember, we're going to be filing these at the United States Patent and Trademark Office. And be very, very careful. This is why I love doing speeches and coming on Facebook, because there are a lot of scams in intellectual property. You know, you have to be very careful because people will play on your emotions and they will tell you that they're filing something for you and send you a bogus certificate. I've seen it all only because my clients show me, right? Because they assume they have something, and then once someone infringes on it, they try to enforce it with this bogus piece of paper and realize it was never registered. Or they hire their friends to do it, and their friends can actually be liable because you can't hold yourself out as a lawyer if you aren't a lawyer. So be careful with that. Misha says, as a new entrepreneur, she's been reinvesting in supplies, but she's on a budget, so you don't suffer the consequences. Okay, well, Misha, you know that this is the beauty of it. A lot of my clients have consultations so that they understand what their options are. So that leads me to my next point. I was talking about people setting goals because, listen, as soon as you know that you're going to launch another business, you actually can file a trademark application. So I'm giving y'all some good knowledge and wisdom and things that people don't know, because you don't actually have to have made a sale. You can file a trademark application as intent to use. So Misha, if you know that you're launching the Misha brand and it's going to be for socks, shoes, and hats, Misha can intend to use Misha for socks, pants, shoes, and hats. You can file the application as intent to use. Now, what's going to happen when you file an intent to use application is it's going to be assigned to a trademark attorney at the USPTO. They're going to research on the USPTO database, and then once they don't find it on the USPTO database, they're going to publish it in the Gazette, and then if no one challenges, then the mark's going to be allowed. Now, I do want to tell you all with trademarks, so I'll talk about what you can do on your own versus hiring an attorney. Well, what you can do is Google. So before you come to me and say, I want to use Misha for shirts, if you already Google and see someone else using Misha for shirts, I know it's not what you want to hear, but cut your losses and change the name now. And the reason that's important is because even if you say, well, the other Misha's selling out of her car, she's selling it, selling out the trunk, and I don't think she's sophisticated, and has a good business. It doesn't matter, because with trademarks, it's not the first to file an application, it's the first to use. So if we do research and you are using your trademark, and people come to me and say, oh, I didn't know I needed a trademark, if we research and see someone already took your name, we can challenge them if we can prove you used it first. So use trumps it, but to challenge is litigation. So that's why it's good to start putting this on your radar, because for some reason, and I don't know why, we see invention commercials. You go and when you have a business, you have to form one, but people do not talk about trademarks. So I'm really, passionate about this, because especially having worked at the patent office, so many people waste money, and they waste it because they don't know what they don't know. So I'm happy to have you all here in the group because you're eager to learn this information. So Yvette asked, if you're a medical provider, what can you protect as intellectual property? Yvette and Dr. Tanya, you said it's a good question. It's a great question. And so you have to think about what your brand is, right? So if you don't know, a few years ago, Dr. Dre, the rapper, sued Dr. Dre, the medical doctor, DRAI. We represented the medical doctor, and we won the case. And the case was for trademark infringement. And so the world went crazy, right? It went viral around the world. And people said, why would this doctor even want to trademark his name? What is a doctor doing with trying to get a trademark? And it opened up America's eyes, because a lot of names are trademarked if they are used for products and services. So Yvette, you have a medical company, Yvette's Heart Association of America, and you provide wellness checkups and services, you can trademark that name. You have a symbol like the Nike swoosh symbol, but yours is a smiley face. If every time people see that smiley face, you want them to associate with Yvette's heart company, we need to trademark that. You have a slogan, taking your blood pressure 24/7, or whatever your slogan is, like that can be trademarked. So Nike has Nike, Just Do It, and the swoosh symbol. Sometimes, Yvette, people's names function as a brand. So let's think about some of our favorite brands like Chanel. You can name your daughter Chanel, and that will always be her name. But if I trademark Chanel for purses and perfumes, and we know that it's out there, you can't sell purses with that name on it. And so a lot of people get confused, because you can think of yourself as a brand. Think of Dr. Oz. Think of, and I'm trying to think of so many other doctors, because I work with so many doctors who are trademarking their names. So your name can be a brand if it's perceived as a brand. And so what's perceived as a brand? Things you spend money on. So you told me today that you spent money, you paid a dollar amount to somebody for a branded product. You bought a piece of candy that had the name Kit Kat on it. You paid a toll to the ABC Toll Company. So I hope that answers your question, and I'm glad you asked it, because people don't know what they can trademark. And to your point, anything that's perceived as a brand for products and services. So you say, I love the name Yvette, fine, but in order to trademark it, you have to identify products and services. And that's important to understand, because I can be Yvette the law firm, you can be Yvette the shoe company, and we can coexist, because no one's going to think that a law firm is selling shoes and vice versa. So that's why the government doesn't allow you just to trademark Yvette. They want to know what it's for. So that's why you see so many people using the same name. And thank you. Yeah, that is my website and email address. And when you go to the site, just click on schedule a consultation. You'll get the forms emailed to you right away. Dr. Tanya, I'm looking forward to your brand and seeing what you do. So I'm excited to see you here today. And thank you as well. Thank you, Yvette, for that question. So let me go back to intent to use, because that may have sparked something in someone's mind where they're like, this is blowing my mind. I love the name ABC, and I've always said that I'm going to use it for medical services, but I know it's on my list of things to do. So you can file an intent to use application as a person, So Yvette, the person, can own a trademark, or Yvette LLC can own a trademark. So I want to point out to you all that the company name doesn't have to match the trademark name, and the trademark name doesn't have to match the company name. So Nike can be owned by Abracadabra Holding Company, but the brand we see on our shirts is Nike, so that's the way we have to think about it. So let's say you come to me and you say, I love this presentation. I'm intending to use Andrea for a law firm, a t-shirt company, shoes, socks. You list everything. If the government doesn't find anything on their database and nobody challenges you, they publish it. Now, if nobody challenges you after they publish it, they allow the trademark. So they're going to come back and say, Dr. Tanya, it looks good. We're going to allow it, but we're not going to register it until you prove to us that you've actually used it. At that time, they give you 6 months to show that you're using it. So that's about 9 months after you file. And at the end of that 9-month period, if you still haven't used it, then they will give you a chance to extend it in 6-month increments up to 36 months. Now, if you get all the way to 36 months and you still haven't used it, you have to file again and start over. But it's really important to start this process, because remember I said it's not the first to file, it's the first to use. And someone has to prove they used it before your filing date. So that's why it's good to get it in. So Misha, you've asked a great question about the difference between an LLC and a trademark. And that's one of the biggest myths that people have when they say, I don't need a trademark, I have an LLC. So basically, when you go and form a company, you can have an LLC, you can incorporate, and you talk to your accountant, or you go to a business lawyer and they help you form a company. So a company is basically an entity that you use to pay your taxes. You may have to get licenses, and that's your company. Your brand, though, is what people see, as a source identifier. So Abracadabra Holding Company can own the trademark for Nike, because when I buy the shirt, the tag says Nike, but the type of company has nothing to do with the trademark. In fact, some people get it confused because their brands match the company name. But remember, Misha, a person can own a trademark. So you can right now say, oh, I haven't formed a company yet, but I know I'm going to use the name Misha for socks, shoes, and hats. Misha, the person, can file a trademark application. And then once Misha, the person, forms Abracadabra LLC, you can assign it to Abracadabra LLC. You close Abracadabra LLC, you can assign it back. But having a company name does not affect the trademark, because some people will say, I've had my company for 10 years, but when I see your brand, you haven't been branding it. So the company is just your entity. So I hope that answers that question. And that leads me to another point. People will say, well, I don't need a trademark. I have the domain name. Your domain name doesn't have anything to do with your trademark either. So a domain name is an address. If I tell you, Tanya, meet me at 12345 Main Street. When you get there, the sign on the store says Macy's. So we would trademark Macy's. We wouldn't trademark 12345 Main Street. Same thing with your domain name. Go to abc.com, but when I get to abc.com, really big, it says EvansIPLaw. So I trademark EvansIPLaw. So that's the way you have to think about it. But having a consultation is good, because this is the kind of stuff we talk about when you're trying to strategize. We want to figure out if our social media names all match. And again, people say, oh, Attorney Evans, I've had ABC as my user handle for 10 years, and now somebody's getting a trademark for that. Well, absolutely, because your username functions as your username and not a brand. So remember, everything you spend money on, because people start saying, I'm confused, I don't understand, just go look at your receipts. Does it have a company name on it? Go look at the tag that says small, medium, large. Does it say Nike, Adidas, or Polo, or and you want to treat your business like a business and not a hobby, because where attorneys make money. Now, I know, the reason people don't hire attorneys, the number one reason they say is money. But we've been talking a lot about money in the group and being cheap and not cheap, and when should I spend my money and make an investment. But here's the thing, you spend more money when you make mistakes or have to start over, or you spend more money when you have to sue someone that registered your trademark to get your own name back. And worse, you spend a lot of money when somebody knocks on your door or mails that cease and desist letter and they make you destroy all of your products because you're using their trademark. So all of that stuff can happen. That's what I do every day. It's not personal, but sometimes when you see me on Facebook, it's because I'm taking screenshots and getting evidence, and unfortunately taking pages down, because people, you just can't take someone's name. So imagine you work so hard to create a business, and you have customers, and you're so hard that you make that first dollar, only to find that somebody comes behind you and they add an S to it, or my, or the. That's not going to be enough. And so step back as you create these names and be unique, choose something. And we're going to talk about that. But last but not least, I want to tell you all, we talked about intent to use. Some of you may be saying, I'm in business. I never thought to get a trademark. I have an LLC. I have a domain name. I thought that was enough. But right now you can say, I'm using the trademark, and I'm using it for shirts, pants, shoes, socks. And then you show that you're using it by a picture, price tag, label. You provide the dates that you use the trademark for the products and services. They research it. If they don't find anything, they publish it in the Gazette. And then if nobody challenges you, it registers. Now, this can take at least a year. So I got to tell y'all, my calendar, thankfully, knock on wood, I stay busy. And I'm so thankful, because from the time I launched my law firm 14 years ago, some of my colleagues said, oh, you're aiming to help the average person, with your credentials, you need to be working with big companies. And I'm proud to say I work with both. But I have to tell you all, from listening to this presentation, you got to get on the calendar, so you have to be patient. So when you reach out to my firm, in my firm, the consultations aren't same day or 24 hours, because people are waiting on my calendar to speak to me. So I want to urge you to definitely go to EvansIPLaw.com, click on schedule a consultation, plug in your information, understand what's required for a consultation, and learn how to schedule, and set it and forget it. Set it and wait. I want to thank you, Sarita, for being here, and hey, Dr. Jaquel, and thank you for trying to share. So you guys have to invite people. So this is just a special event today. We're celebrating World IP Day. Woo! Okay, I'm having my own party over here with you all. And so invite people to this community, because I wanted to do something special for you all, especially with all of the discussions that have been going around in the group, and so I created this group as a platform to share current events, for you all to be able to ask questions, but I want to make sure you get good information. And so there are a lot of people saying, hey, for $5 I can trademark this and that. And so I try to do my best to delete things like that, because first of all, if someone says, you can trademark something for $100, the government fee costs more than that. So that should be a red flag. But I do want to point out, the Patent and Trademark Office is uspto.gov. And if for whatever reason you file on your own, you never get anything in the mail from them except for your trademark at the end of this whole process. You work with the law firm like myself, all you get in the mail is the trademark at the end. So be very careful. And the reason I'm saying that is because when you file an application, you get a bunch of spam mail, fake bills, and it looks really official. So we're going to be filing at the United States Patent and Trademark Office. You'll get spam mail from United States Patent and Trademark Agency. So it's really, really close. Thank you, Monique, for being here. I'm glad that you are finding this information helpful. And Yvette, thank you. But last but not least, and Sarita, thanks for tagging your friends to this presentation. If they miss it, I'm going to leave it here. And then I'm going to probably add it to YouTube then, so we can share the YouTube video, because more people need to see this and learn more about intellectual property, why you should protect it. So before I move on to copyrights, post your questions in the comments. Does anybody have any questions about trademarks and what can be trademarked and who, what, when, where, why? Ask me your questions, and I'm going to take a sip of water while you post your questions. I'm going to give you a few more seconds. And I want to encourage you all, if you're in a situation where you say, look, I really can't afford a lawyer right now. I can't schedule a consultation. I want to encourage you to purchase my books. So I talked to you all about patents in my All About Inventing book. Check out All About Trademarks. So All About Trademarks explains the trademark process. And since Dr. Tanya said I was phenomenal, I got to give y'all one more tip then. So we're talking about trademarks, and I want to encourage you all, especially as you get started, to create a strong trademark. Now you're saying, what is a strong trademark? A word you make up is the strongest. Google. So you make up a word that makes sense that it's going to be a strong trademark. You made it up, so it's less likely someone else would have it. Then you go down the spectrum to words that are arbitrary. So apple for computers. We know apple is a fruit, but apple for computers becomes a very strong trademark. So think about that. Giraffe for a law firm, zebra for a shoe company. You can think about a name like that. So I want to point that out because I see people saying, oh, you can't trademark a common word. Well, what's a common word? You know, what is a common word? And yes, I see my client Nidella here, so that's a strong trademark. She made that word up. So that's what you want to think about. And it's good to see you here. And then you want to stay away from descriptive terms if you can. But sometimes people say, well, I want to be more descriptive. So as soon as you hear my name, you know exactly what I do. But descriptive trademarks become weak. So you want to be lavender for a law firm, that's strong. But you want to be lavender for a lotion company. The government's going to say, okay, if nobody has it, we'll give it to you. But don't be surprised if people use it in a sentence and Laura says, my candle smells like lavender. So, you know, just be careful. You have an uphill battle because it's used in a descriptive way. And then last but not least, you definitely don't want to trademark or even attempt to trademark generic terms. Shoes for shoes, socks for socks. You cannot trademark generic terms. Now, Mark is saying, does the USPTO benefit from protection of their name? You know, Mark, this is something that blows my mind and even my clients, because you get so much spam mail. United States Patent and Trademark Office is the real agency. The United States Patent and Trademark Agency sends you a bill, you know, and there's so many people, and I don't care how educated you are, you know, they don't read the fine print that says only write a check, only wire, and you may just be assuming you're handling your business. So the Patent Office, I'm not sure what they're doing about it, but if you go to their site, you can definitely read. They have a whole page on fraudulent emails, and it's very interesting because they require that you put your email now, and they actually changed it where you can't put a P.O. box on your application. So they're requiring street addresses and email addresses that go public on the Patent Office site, you know, which is a public website. So what does that mean? There are companies that just sit back and start spamming you. So that's one of the benefits of hiring an attorney, you know, to avoid all of that, you know, because I don't know about you all, but running a business and you running a family and running your life, you know, just running, period. It's good to know you're in good hands for different things. Okay, you answer the phone, you send an email, you do this, and you just don't have to worry about it. But that's a good point. And it's very interesting. I think they're trying to do it, but what happens is as soon as they catch them, the company changes their name again and the mail goes out, you know, so they only know because people complain. And what ends up happening, Mark, is people pay the money and it's not on a credit card. They require wire or check. So what happens is gone. You know, you can't get that money back. And when you call the bank and say, hey, I paid the agency $1,000, and they say, well, did you do it yourself? Did they force you? You know, so it's hard to get your money back because once that money is wired or that check is written, it's gone. So be careful with that. And good to see you, Mark. Thank you for asking that question. If you all don't have any more trademark questions, I'm going to move to copyrights. And so we talked about patents protecting inventions, trademarks protecting the names of those inventions, copyrights protecting your written work. So you write a book, you are going to copyright that at the Library of Congress. Now, here's the thing about copyright. So we talked about trademarks. The Patent and Trademark Office, they're going to research your trademark. So when you file Andrea for a law firm, they're going to look up other Andreas and say, oh, I'm sorry, somebody already has that. Well, when you upload your book at the Library of Congress, they're not going to read it and say, oh, this sounds like Sarita's book. Both of you wrote the same thing. So they're not basically examining it for confusion. They're examining it to ensure that the application is correct. So, something to think about. Now, the way this works is basically as soon as you put the pen to paper, you own the copyright. So you're taking notes today, you own the copyright. You write a book, you own the copyright. But although it's not required that you register it at the Library of Congress, it's recommended because it's required to have the copyright registered at the Library of Congress to sue someone for infringement. Now, excuse me, I know that's a mouthful. No, people are saying, now, what does that mean in plain English? So here's what it means. If you write a book and you have a copyright registered at the Library of Congress, and I go and copy and paste your book and post it here in the site, you can sue me. If you have the copyright registered before I copy it, you get more damages than you would have if you wait. So if you go and try to scramble and you try to copyright something after the fact, then you get less damages. Now, Sarita says, how long does it take? It can take almost a year. So, we're dealing with the government. So, that's one of the beauties of this type of law, right? It's not very stressful unless you're dealing with stressful people. That can be stressful. But it's a very positive and sort of happy law, right? Because it's your intellectual property. So it's not something that's tangible, but it's yours, and it's something that can be part of your legacy, and the benefits are endless. And I'm going to end by talking about the benefits, but I want to encourage you all to get in the habit of writing things, your blogs, your songs, or written works, and registering them at the Library of Congress, because if it's registered before somebody copies it, you get more damages than you would have had you waited. Now, to your point, Sarita, if you have all these notes and Jane comes on and copies your notes, and you say, oh, I can't believe this. Well, normally it takes a year. So now, instead of waiting a year because you need that copyright to sue, you have to pay to expedite the copyright. And to expedite it may be $2,000 instead of $55. So I know everybody's money conscious, so it's good to just have things in order. So Misha says, would you have to get a slogan or a trademark? Okay. Would you have to come up? Okay, so all right, Misha, so that's a good question. So that's very specific, but I'm going to answer it. I wasn't going to talk about this, but I'm glad you brought it up, because what has happened during this pandemic is there have been a surge of businesses, and the trademark office hit a record, the most trademarks that have ever been filed, ever in the history of the office. And it's because people are home, people have time, people are realizing life is not guaranteed, so they're out here living their lives and doing things differently, and they have time to invest in their businesses, right? And so most people started creating clothing companies. There are a lot of print-on-demand companies, so you don't even have to have a warehouse. You can order a shirt, another company can print it, they get $10, you get $10, and everybody's happy. Now, what the law says, though, Misha, is if I'm walking down the street and my shirt says, today is my birthday, and it takes up over 50% of my shirt, you're going to see that as a cute design. I'm a patent attorney. I'm smart. Today is my birthday. And so when you have something that takes up over 50% of the shirt, that's just a cutesy ornamental design. So it's not a brand. It can't be protected as a trademark because it's very weak. It can be, but it's going to be weak because it's 50%. So what you want to do is when you look in the tag, though, if it says, today is my birthday size medium, today is my birthday 1999 tag, a bag stamped, today is my birthday, now people perceive that as a brand. So to your point, your brand may be Misha size medium, but the shirt may say, I'm smart. And so you would be trademarking Misha. And all those expressions on shirts are why you see so many other people with the same expressions. I run fast, Nike. I run fast, Adidas. So if it's your intention to take that big expression on your shirt and make it a brand, then you need to get into I'm smart 1999. I'm smart size medium. I'm smart on the bag. So that's how you think about it. And those slogans cannot be copyrighted because you can't copyright a word or just one sentence. So I'm glad you brought that up because a lot of people don't understand that. So thanks for asking that question. And I want you all to start thinking about your intellectual property, start thinking about patents, trademarks, and copyrights, and definitely think about Evans IP Law if my firm can help you. And I'm going to make sure we get this posted on YouTube for you all to share. But I wanted you to see it here live today on World Intellectual Property Day. And I want to leave you all with the benefits, right? Because some of you are saying, why do I even need any of this? And intellectual property is like real property. So whatever you can do with your real property, like your house, you can do with your intellectual property. You can sell it. You can will it. You can license it. You can assign it. You can also register these copyrights with customs. So if you think you're going to have a lot of people, you're making purses and you want to go register it at customs, that's a benefit because they're supposed to stop people from bringing in your purses that are infringing on the border. You know, there's so many benefits. But personally, what I love about it, and here's another bonus tip about trademarks, as long as you use the trademark, you get to keep it. So every 5 years, I'm going to come back and say, Misha, you still have the Misha brand for shirts. You show me that you're using it. Misha, you can keep that name forever until you stop using it. So Coca-Cola has had the oldest trademark. They've had that name since the 1800s. So talk about a legacy. When you're gone, your daughter's gone, their daughter's gone, they can keep it. So right now, you're making $100 a year from your brand. It's no rule that you have to have a certain amount of money to qualify as a trademark. And I've seen firsthand that if a company wants that name, they have to respect your intellectual property and they have to pay you for it. So that's what I'm doing every day, helping to register trademarks, helping to enforce them, and helping to negotiate good deals on behalf of my clients. So if I can help you, definitely reach out to EvansIPLaw.com. I want to encourage you all to text EvansIPLaw to 33777 so you can be on my firm's newsletter, or just go to EvansIPLaw.com. I have a blog on there that has a lot of good information like this. I'm everywhere on social media at EvansIPLaw. And I want to thank you for being here. So Sarita, it's better if you can to copyright your works when they're not published, because if you publish it and then copyright it, you get less damages. So you can get in the habit of making something not published and then go ahead and file the application. But it's the benefit of this conversation today is you have the option. So if you're saying, oh shoot, I've already written my book, I didn't copyright it, you can still do all of this stuff. So that's what I love about this type of law. And I'm so thankful to be an expert in this area and to be working with so many of you and Dr. Jeffries. Yes, I'm excited for you too. And I'm just so excited because when I started my firm 14 years ago, many of my clients would come into my offices with napkins and, you know, this circle represents this. This is a sponge. This is that. And now they've been on Shark Tank. They're selling globally. They're selling in national stores. And I get to say I'm part of that. So I know, you know, that you all have plenty of options, and that's fine. But definitely consider my firm. You know, this is what I love to do. I'm just so thankful to be really living what I'm passionate about. And if you aren't ready to have a consultation, check out all of my best-selling books. They're sold on Amazon or evansiplaw.com/books, all about inventing, all about trademarks. And I have a third book for all you inventors to help you get organized, all about my invention, an inventor's journal and planner. And it's a quarterly journal and planner. And that was my COVID-19 project, because during this pandemic of social distancing, a lot of inventors called and they were all over the place. You know, I don't know who I talked to, when I talked to. My notes are all over. I can't find this paper. So I realized that there was no resource. So I kind of invented a journal and planner, but you can't patent a book. So I have it copyrighted. But, you know, just goes to show that You got to act on these ideas. You know, my trademark, like I said, is invest in your idea. So it can seem like a lot when you're trying to get things done, but a couple of $1,000s to have something worth millions of dollars, to have something that lasts beyond your lifetime, to me is priceless. So that's how I'm going to end this today. I'm so happy to see so many of you here, and I want to thank you for celebrating World Intellectual Property Day with me today. And got to jam a little bit. All right, so y'all get your dancing shoes on because it's World Intellectual Property Day. Ooh. It's supposed to be all I do is win, 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 no matter what. Okay, so y'all got it? All right, so we're just celebrating today. So keep the party going. Definitely let everyone know that you celebrated World IP Day with EvansIPLaw. This is a real day where people all over the world are celebrating innovation. And it's a true celebration because I want to applaud all of you that take the time to protect your intellectual property. So definitely add it to your to-do list. If it wasn't on your goal list for 2021, get it on the calendar. We're in the second quarter, so you can file now, and hopefully by the beginning of January or so, you can celebrate. You know, we can celebrate. That's right, girl. Oh, that's a good slogan for you, Dr. Wynn. That's good. Thank you, Misha, and thank you for. I dressed up for you all today with my sparkles to celebrate World Intellectual Property Day. So thank you for noticing my outfit, and just thank you all for your time today. My name is Andrea Evans, and I own the law firm of Andrea Hence Evans, a patent, trademark, and copyright law firm. We represent clients around the world with patent, trademark, and copyright matters. And this year will mark 14 years, so we're going to have a big celebration in July to celebrate my 14th year anniversary, so stay tuned for that. And I'm going to do something big, so just stay tuned. And you're going to know about it because you're going to be in the group, you're going to be on the newsletter, so you won't miss anything. And thank you, Dr. Jeffries, for saying I'm always gorgeous. But I think I'm just glowing today, a little bit extra because it's World IP Day. And I'm just excited about this day and glad to be able to be a resource to all of you to let you know about patents, trademarks, and copyrights. Check out my best-selling books on Amazon or evansiplaw.com/books and spread the word that it's World IP Day. And follow me everywhere at EvansIPLaw. And I could just go on and on about all the good news and things going on today on World IP Day. But I want to be able to come back and share your good news. So when you get your patents and you get your trademarks and you get your copyrights, spread the word, because just telling somebody that you did it is enough to inspire them to get it done. And I want to encourage you all because the Patent Office just put a study out that said that women and minorities are least likely to protect their intellectual property. So let's change that. Let's get it done. And I'm convinced that it's because we don't know what we're supposed to do. You know, it's not something that's often talked about. So I'm so happy to see so many of you here. And thank you for this great conversation. Linda, thank you, girl. I know you're celebrating. Just another reason to party today, a little bit extra, and it's Monday, so why not? So this is a good start of a good week, and I want to wish you all the best. And this is the last week of the month in April, so make it count. I'm gonna go check my emails to see how many of you reached out to schedule a consultation. So click on that schedule a consultation button. Put the form information in. You'll be emailed immediately information to schedule your consultation. So I'm going to be looking out. I'm ready to talk. Let's make it happen. And thank you, thank you, thank you. Happy World Intellectual Property Day. And I'll see you soon. Bye, everybody.